Hope everybody's doing well. I am here with a good friend of mine, Cindy Sayegh. She's a trust and estate planning attorney in Walnut Creek.
Hi.
Cindy, how you doing?
Good to see you. Thanks for having me.
Good to see you. Tell us about you and your background and how long you've been in business and what is your practice?
So I have been practicing in the areas of trust and estate law for the last 12 years. I'm primarily focused on estate planning, trust administration, and non-contested probates.
So when you say estate planning, what does that look like? A lot of people, they might not even know what that means.
So essentially, an estate plan is the legal documents that you need to prepare to basically say, upon my death, here's what I have, here's who I want it to go to, here's the rules of how those people are going to receive these assets, and here's who's in charge of making sure it happens. So it's basically tying up or accounting for all of your legal affairs upon potentially your incapacity, but specifically upon death. So we're talking about trusts, wills, powers of attorney, and medical directives.
Now, some people, they believe that if they have a will, if they can just handwrite a will, that's good enough, that they don't need to do anything else.
Yeah, so that's a really common misconception. It's not actually true. Will still requires in California for you to go through probate. A probate is the whole court experience or process of administering the estate. So a judge is appointed, they're choosing who's in charge of administering the estate. It's tens of thousands of dollars and it typically takes a few years. So the will doesn't prevent that process. The will just provides guidance. The trust is really the document or the vehicle, so to speak, that helps you avoid the court process.
When you have a probate, and let's say the parents didn't have a living trust, and now you got 5 kids, how does the court choose which one of these kids will be the administrator, if any, or will the court choose somebody else?
So if you have a trust or a will set up where it designates who's in charge, then of course, the judge doesn't rely on that.
But probate.
For a probate with no will, you essentially have 5 equally available people.
Yes.
So typically, hopefully those folks are going to work together to nominate and choose among them who's going to do it. But if there's competing petitions or competing parties interested in this role, then the judge is essentially going to consider evidence or opinions as to who or why makes more sense. And more often than not, when people can't agree, the court actually has to appoint a third party, a stranger or a professional fiduciary to actually be the administrator.
And when they are the administrator, are they appointed? Is there compensation that they also get paid for doing that?
Yeah, so with a will, with a regular executor appointed or an administrator when there's no will appointed, everybody in those respective roles is entitled to what are called statutory fees or probate fees. So typically with probate fees or statutory fees, the statutory probate code is setting that payment. The lawyer is paid, what the administrator is paid, and it's a percentage of the value of the estate.
Got it.
So it moves on a scale, for example, 4% of the first 100,000, 3% of the next 100,000, and that scale is adjusted based on what's called an inventory and an appraisal that a probate referee puts together once the probate's opened and things are moving along.
And the fact that if they don't put together a living trust and it goes through probate, how long is the process of a probate?
Right now in our county, which is Contra Costa County, you aren't even getting in front of the judge to open the probate for about 5 months right now. So at the very least, you're waiting several months to get in front of the judge. Then there's a minimum of a 4-month waiting period, which is called a creditor period, where any claims can be filed against the estate. After that creditor period, then you're petitioning to close the estate. So you're waiting another 5 to 6 months to get in front of the judge. So I would say, generally speaking, on a best case scenario where something's really organized, there's no fighting, all the assets or bank accounts are you can discover them easily. The banks work with you. You can sell real estate right away. In the best case scenario, you're probably looking at 18 months. More realistic is around 2 years.
And you were talking way more money that they're going to have to pay in attorney fees, correct?
Right, yeah. So typically, if you're setting up a trust, you're spending the parents in your example are spending several $1,000s to set up the trust. So they're kind of making an investment on the front end. Then they pass away, rather than spending tens of thousands of dollars with lawyers' fees, those statutory fees I mentioned before, plus the court costs and expenses, plus the administrator fees and whatnot, you're spending, depending on how much help the client needs as the trustee, but a few $1,000s, up to maybe $10,000, again, instead of tens of thousands of dollars. Really varies on, of course, the client and their needs.
When we talk about this, it's you would think that anybody in their right mind would be like, well, it makes sense. I'd rather go spend $2,000-3,000 than have my kids have to go do all this. Why do people refuse to get a living trust?
I think there's a couple of things going on. People don't want to spend the money. There's a just a principle resistance to, I'm not spending thousands of dollars. My estate is simple. Everything goes to my kids. It'll be easy for them. They don't really appreciate the complexities of a probate, so they don't want to spend the money up front. That's very common. There are also a lot of people who just really don't want to deal with it. They don't want to consider and kind of face their death and the whole concept of their mortality. They don't want to get into these uncomfortable places about, well, what if there is conflict between my kids? Or what if one child does get this and one child doesn't get this? I think it's just a combination of, it's uncomfortable, it's expensive, I don't want to spend the money on it, and I just want to kind of avoid dealing with the situation.
And when it comes to a living trust, once they do decide to do it and they have 4 or 5 kids, if they choose one to be the trustee, does that mean that one kid is going to get more than everybody else?
Yeah, no. What's difficult to that point, when you're a trustee and a beneficiary, you have to remind yourself you're wearing 2 hats.
Yeah.
So I have a job as a trustee to act as the fiduciary. I have a separate legal obligation to act on behalf of the trust, the estate. And then I'm also an equal beneficiary with my siblings over here. So I might be in charge as a trustee as far as making the decisions, selling the house, liquidating the accounts, paying off the taxes, and then dividing what's left in the 5 equal shares or what have you. And then I'm also over here as a beneficiary getting my equal share compared to my siblings. Get more money just because I'm the trustee. I could pay myself compensation if the trust allows me to do that, and the laws allow for that up to a certain amount. But as far as an inheritance goes, no. You get equal share, or you get whatever the trust says you get.
Now, what about if somebody says, I don't want to spend $3,000-$4,000 on a living trust. What I'll do is, while I'm alive, I'll just transfer everything to my children.
Yeah, so actually a lot of people do that. And you would of course want to talk to your attorney and your CPA or financial person regarding, does it make sense to start doing some gifting while I'm alive? Do I have a taxable estate? Do I want to start moving assets out from a tax perspective? But there are tax implications with gifting, for one. And as you probably know, with Prop 19, there's a huge implication. If I'm going to start gifting real estate over, how is that going to impact my kids from a capital gains perspective? What does that look like from a property tax perspective? Those are all competing interests that have to also be considered. It's not as simple as, I'm just going to give things over and that takes care of it. No, that triggers all sorts of other potential tax consequences.
Right. So now let's say somebody says, you know what, I watched this video, I think I'm going to go ahead and get a living trust. If they want to get a living trust, what's the process? What does it look like?
So for my process, what I like to do is have clients call in or email. We send them a summary typically, just to kind of expect of, okay, let's set a meeting. We're going to go through a questionnaire together. We're going to talk about your family. We're going to talk about your basic background details. We're going to talk about your assets. Where are your bank accounts at? Do you have life insurance? What are your retirement accounts? What properties do you own? Do you own a business? And really understand that every single penny that you own, we want to have accounted for either via the trust or with beneficiaries and what have you. So we usually do that at the first meeting, where we're really talking through those details and then really educating the client on what is a trust versus a will. Why do I need a trust and a will? What is a trustee? What is an executor? Kind of like I mentioned at the beginning, really understanding, here's what I have, here's who I want it to go to upon my death, here's the rules of how those people are going to receive it, and here's who's in charge in the case of a trust, the trustee for overseeing all that. So we're talking through at the first meeting a trust, a will, a financial power of attorney, a medical directive, and talking about the different roles that are relevant in each of those documents. Assuming clients are able to make decisions in that first meeting, we put together drafts based on that meeting. I usually send drafts out within 2 weeks from that meeting, just because it helps when it's fresh on everybody's mind. We talk again to review questions or changes. Usually we schedule the appointment where they come back and sign 4 to 6 weeks from that initial meeting, just so that we can make sure that everything is wrapped up. And then part of that is moving assets into the name of the trust too, like real estate, for example.
Because some people, the mistake they make is they create a trust and they put it away and they never look at it again.
Yeah, very common.
Correct?
Very common.
And that could be a problem down the road if they go buy more properties or if they do something else. What happens then?
So a couple of different things. There is a case in 2016 which allowed for a little bit more leniency as it relates to assets that weren't moved into the trust and trying to avoid probate. I will, when I have a situation like you've mentioned, I'll evaluate what the estate plan documents are, that if it's addressed, is there a way for us to go to court, what's called an 850 or a Hegstead petition to still move assets into the name of the trust, or no, we really don't have any facts supporting this. The clients really didn't move anything ever into the name of the trust and didn't operate like it even existed. It just really depends on the situation of, are you still forced into a probate? Hopefully not. Usually if there's an existing trust, especially in our county, there's a lot more tools available to avoid the probate still.
Now, what are some of the other mistakes that people do when they create a trust? Like they forget, let's say for example, they have another child. What about if they forget and they forget to add that other child?
Generally speaking, most trusts are written where they account for additional children. So it will say, for example, my estate is distributed to my child or children in equal shares. So usually trusts are written that way to account for that. If you're limiting to a specific child only, then that's a different conversation. Also, to be clear, there are laws that essentially account for, a child, what's called an omitted child, where they were accidentally left out or not planned for. The idea is that you always would have intended to provide for a child or a spouse unless they were specifically excluded.
Now, some people think that just by creating a trust that they're protected from any legal,
yeah,
right?
That's really common.
I mean, is that correct?
That's
they're
not correct, no.
Right? And also, what about, there are folks, so let's say, for example, they've created a trust, a living trust. Now, they go to a nursing home. They're in the nursing home for 5 years, and then they pass away. Can Medicare, Medi-Cal, can they put their hands on that money and say, wait a minute, we need to be compensated first before any beneficiaries or anybody else gets their money?
Yeah, I mean, there's definitely yes and no's to both sides of that question. So depending on how your trust is set up, does it account for Medi-Cal planning? If you have a situation where somebody is on Medi-Cal, do they have what's called an asset preservation trust? There's just different ways that all of that can be addressed, and it just depends on your facts and how your estate plan is set up.
When it comes to, even if there's a living trust put together, what are some of the problems that you're seeing between the beneficiaries? Like things that arise, that it could become a lawsuit, or like you said, something about the trustees, they have the fiduciary duty, so they got to be very careful if they want to choose that a role. But like between the beneficiaries, what are some common things that you see that it could have been avoided?
Yeah, I think one of the biggest issues that run into when you have multiple beneficiaries, usually siblings, is essentially people have different ideas of what they're supposed to do with a business or a real property, for example. So if I can think of an example of a client I have right now where there's a specific property and they left that house to a specific child. The idea was that child can have this house if they want it. If they don't want it, then we'll sell the house and it can be distributed to the rest of the kids. But we wanted this child to have the house, versus just saying, well, everything's going to go to the kids equally and they have to work it out. Maybe that is the case, but if you have an idea about someone getting specifically, it's better to call that out from the get-go. On the flip side of that, though,
and the way you called that out was by putting it in a will.
In the trust.
In the trust. In the trust.
Rather than saying everything goes to my five kids equally, you're specifying specific pieces or dollar amounts or real estate or business and what have you. I do think, and that really also applies to like, oh, well, I want it to be fair between my two kids, so everything's going to be sold. Well, what if one of the kids live with you? What if that's been their primary residence? How long do they get to stay in the house? If the sibling's a trustee, do they have to evict them right away? A lot of times people don't consider, what are our children's relationships like? Is this kid's feelings gonna be hurt because this person's the trustee? You have to really evaluate, like I was saying earlier, get in these uncomfortable places. What makes sense for the kids? What's gonna be most, agreeable for them? And then another piece, again, even if people are getting things equally, what if someone wants to keep a house and what if someone wants to sell it? What if the trustee is tasked with, well, I have to make everything equal and there's competing interests between the siblings? Whose opinion are they gonna take? What are they supposed to do? Their job is to benefit all of the beneficiaries of the estate. So that's another thing, is just trying to understand how the trustee, who's really the ultimate decision maker, is going to meet their fiduciary responsibility of what's most advantageous for the trust.
Have you ever had parents where they had a living trust but they never told their children? So then they passed away and the children said, oh my God, we got to go through a probate, but there was actually a living trust but they couldn't find a living trust. Has that ever happened? Because that is not public record.
Right.
Like, you would never be able to know. The only person who would know is the person who drafted and created it for you. Correct?
Who might not even be alive.
Who might not be alive.
Have a copy,
what do you do then? Like, you got to go through the whole probate?
Yeah. So no, I have had a case recently. A lot of this depends on the facts, again, and like who the beneficiaries are. I had a case last year in this county, actually, where we did have a property deeded in the name of the trust, but no one knew where the trust was. There was no proof of the trust. There was no way to show that my client who was going to be the trustee had authority, because when you go to sell a house, the title company wants to see the copy of the trust. When you go to access bank accounts, they want to make sure you have authority to do so. Well, we didn't have a trust to provide anybody. In that case, we had two siblings who got along, who wanted everything to be equal between them. So it was very simple to petition the court to say, hey, judge, these are the only two children of the decedent. He deeded this property into the name of the trust, and he had this bank account in the name of the trust. We don't have any proof of the trust, but if this went through probate, it would go to these same two people. So in an effort to be efficient and save them money, can we just have this trust ordered as valid and have my client appointed as trustee to move things along? But what if you had a situation where people were fighting, or if there was someone who was estranged, or there was, I don't know, some sort of a conflict? It wouldn't be that simple. And yes, you would have to go through a probate.
We talk about properties, they might have real estate property, stocks, bonds, whatever. But what about personal sentimental stuff at the house where, that's not all in the trust, right? To say like here's a Persian rug or whatever, jewelry or couch or whatever. Like what happens? Obviously when they, who says this is mine, that's yours, no, take this. They had a living trust, they had everything, but all the personal items were not written down. You get this, you get that. What do you do then?
So depending on the situation, you might say, I just want everything to go to my kids equally, and the executor who's appointed is going to work it out with them. Maybe we have a situation where everybody gets along and it's not worth anything anyway, we don't care. Or maybe you have a situation like that where the client puts together what's called a codicil, where they've handwritten, my couch goes to my son, my desk goes to my daughter. Maybe they have kind of created a codicil is a legal document, or even like a cheat sheet. Clients sometimes will put like yellow Post-its all over behind pictures. But when you have a more sophisticated or complicated situation, then typically what you're doing is you're just directing everything to the trust through the will, and then the trustee is really taking an inventory of all the assets and creating some sort of a situation where they're either selling, liquidating assets, giving people kind of like a lottery as far as the kids to go through items, and a more fair process.
When do you think it's beneficial to get a living trust? When you have a real estate, you actually have to have real estate for it to be worth, for you to get a real living trust? Or can you have a condominium? Could you be renting somewhere, but you got cars and you got stocks or bonds, whatever else?
Yeah. So I think anyone who's over the age of 18 should at the very least have a power of attorney, a medical directive, and ideally a will.
Okay.
I'm 20 years old. I don't really own anything. My mom and dad will take care of everything, or my parents will take care of everything for me. Well, you need a power of attorney for medical and financial for college, for example, because your parents can't call and talk to the doctor once you're over 18. But from a trust perspective or a will perspective, really you want to trust when you have real property almost exclusively, because that is the way that it transfers. People look into these transfer on death deeds. They don't work for selling property. You still have to go through a probate with the title company. So really we want to avoid transfer on death deeds. And the trust is the way to avoid the probate. Maybe you don't own real estate, but you have, to your point, stocks and bonds. You have investment accounts. You have vehicles. Could you get away with avoiding the trust? Possibly, as long as everything goes to plan. You have every single asset titled in your name with beneficiaries designated, and you've planned for contingencies. So if I own an account and I put my child as a beneficiary and I die, that account goes to them. Well, assuming they didn't die with me, assuming they're over 18, assuming they're responsible enough to know what to do. It's definitely easier, so to speak, to have everything come to a trust because it's consolidated and you have the person you want responsible to take care of all of that. But there's flexibility on that if someone really is against having a trust. The trust really gives you ways to manage the money and the assets for children or beneficiaries up until certain ages, and has the people you want responsible for doing all of it.
How often should somebody revisit their trust just to look at it, do an audit of their own trust?
I advise my clients to check in every 3 years. It's 3 to 5 years is probably pretty common. And then I always just say, hey, anytime you're doing anything with your assets, even if you're going to do a refinance on your house, even if you're getting a new job, you're going to open a new bank account, just check in with me, send me an email just so I know what's going on and I can tell you quickly. Let's make sure you open that account in the name of the trust. Let's make sure before you close escrow on some timeshare or some property property in another state that you are opening or getting it titled in the name of the trust. They're just little things that people don't think about that create these other problems that you've mentioned earlier.
And whenever you create a trust for somebody, I'm assuming you probably keep a copy for at the office too,
right?
Just in case if they lose it
right.
or whatever,
yeah.
right?
Yeah, and we have electronic copies of everything too that we share.
Okay, so anything else that you know, for folks that are watching right now, especially, you know, even when people are buying a new home, you know, there's already, you know, strapped as it is. We always recommend get a living trust. Oh, I'm going to live forever. I'm going to live whatever, you know. You know. So anything else you like to suggest, recommend?
Yeah, I mean, I think this kind of goes back to what we were talking about, but part of buying the house process should ideally include just having the trust set up, because then the house is just put into the name of the trust from the get-go, and you can forget about it until you do a refi, sell, buy another property, as far as the trust goes. Otherwise, you're looking into spending, you know, the thousands of dollars down the road to get the trust set up then. Why not just do it all at once, right? And then the other thing that I think is important to think about, to your earlier point, and especially with what's going on right now, you know, we have an aging population, there's a massive transfer of wealth going on.
Big time.
Yeah, and so a lot of people I've had recently are really bringing their parents in to have their trusts reviewed and trying to make sure that everything's cleaned up and reflecting the current law. Talking to your other point, you know, are there things we could be doing from a tax savings perspective right now? What if one parent passes away? Let's make sure that the other assets are actually in the name of the trust, so then if something happens as far as a capacity issue or upon the second parent's death, it's not pushing us into probate or these one-off Hegstead hearings I was mentioning earlier. So it is always a good idea just to review things and to check in, just to talk about if it makes sense to set up a trust now or consolidate things for any reason.
If somebody wants to get a hold of you, and you know, how does that work? Do you guys do a consultation or?
Yeah, usually most of our clients, we have, you know, a number of clients who come in through our website, which has like an intake form, and my office manager, Kelly, usually contacts those people and gets back to them. And
what's your website?
It's Cindy, C-I-N-D-Y, Sayegh, S-A-Y-E-G-H, law. So cindysayeghLaw.com.
Okay.
Tells you kind of like what the estate planning process is, that all of our fees are online as well, which kind of helps people have a sense of what they're going to spend, and that intake form.
Okay.
Or people will call often. We get most of our referrals are all word of mouth. Most of my clients are all word of mouth at this point. And so they'll come in through their financial advisor or just call in because, oh, my sister used you or my neighbor used you. And Kelly usually just chats with people right away. And sometimes people want to talk up to me first and make sure it's a good fit, or just understand, you know, what is the process with me specifically, and I'll chat with them. Otherwise, they'll just schedule with her from the get-go.
And then your office is in Walnut Creek, right?
Yeah, so we're in Walnut Creek near the Whole Foods and Kaiser.
What's the address?
It's 1211 Newell. It's just at the top of the hill. There's free parking. Very easy to get into.
Nice
first floor. Mobility issues, you know, doesn't deal with it.
And if somebody wants to call your office, what's your phone number there?
It's 925-252-5700.
Beautiful.
Yeah.
Anything else you'd like to say?
No, I just want to thank you for the opportunity, and I'm glad to help anybody.
We appreciate you. Thank you so much.
Appreciate it. Thanks, Alex.